High Court recently reserved judgment in an application that has the potential to pave the way for divorcing spouses who were married out of community of property to be compensated for what they consider to be their financial contribution to the marriage. Let's discuss the implications if this order is granted. I'm joined by Shani Van Niekerk, Senior Associate at Adams and Adams. Shani, very good afternoon to you. Thank you for your time. A judgment with the potential to pave the way for those who are divorced couples married out of community of property and without the accrual system. Tell us more about this case.
Good afternoon. I think where we should start is just to point out to people that there are three ways to get married. It's in community of property, out of community of property without the accrual, and then out of community of property with the accrual. Now, this development in our law will only affect people that are married out of community of property without the accrual. What the applicant has done, she has approached the court and said that a certain part of the Divorce Act is unconstitutional. The Act reads that parties that are married, that were married before 1 November 1984, they are entitled to a redistribution claim. A redistribution claim simply means that regardless of how you are married, a court is entitled to hand over some assets or a sum of money upon divorce to the other party. Now, the applicant in the application that was before the court on the 11th of March was to ask that only before 1984 be invalid and say that redistribution claim must be applicable to any person married out of community of property without the accrual, regardless of when the marriage was entered into.
It really is an interesting take, especially considering what the benefits would be for those without the accrual system married out of community of property, which would essentially mean that you just walk away, if I'm correct.
Yes, so the benefits, should the matter be successful, is quite clear. Say for parties that are in a marriage for 30 years and they are married without the accrual and they divorce without this redistribution claim, the one party will basically walk away with nothing. And so in those circumstances, we can see the merit and understand what the benefits would be. But we should, however, keep in mind what this, the negatives of this matter could be if the matter is granted.
And what will the implications be if this matter is indeed granted? What will it mean?
The floodgates to litigation will be opened. I mean, many people who are in marriages who knew that they weren't entitled to anything will now be entitled to a something. That means also that what does your antenuptial contract really mean? What is the effect of your antenuptial contract? And what is your right to contract? A third party such as financial institutions will be affected. Are you able to buy a property, sell a property without your spouse's consent? There are various factors on the patrimonial aspects of a divorce that will come into play.
Does this now mean, should it pass, should it all be granted, will it nullify prenuptial contracts?
It will not nullify the contract, but it would mean that if you elected to be married out of community of property without the accrual, your intention was not to share any assets with your spouse, regardless of what happens in the future. With this matter, if it is granted, that discretion lies in the court. The court will have the discretion to look at your antenuptial contract, take into account what it says, but then despite that, order that either the wife or the husband be granted with certain of the assets of the other parties. The court will have to, however, look at the contribution that the one spouse made to the other spouse's estate, indirect and direct contributions. And what is very important to remember is that through case law, in respect of these discretionary claims, your contribution is not necessarily only a financial contribution. For example, a woman who has been looking after children, taking them to school, fetching them from school, that is contributing towards empowering your spouse to build his estate. So that's why a 7-3 discretion will have far-reaching consequences on various marriages.
Now, in this specific case that we're looking at now, as we try and assess the strength of the legal argument, what's been put down that could be a game changer for this case?
A game changer is that the Pretoria Attorneys Association intervened in the matter as the amicus curiae, because what is important to note is that the application was unopposed before the High Court. The amicus curiae intervened and asking whether there is really locus standi and how this decision, can it be retrospective, and how far can it be retrospective? You know, will it be unconstitutional before the inception of the Constitution or only afterwards? And I think that is one of the key issues that the court will have to consider in respect of retrospectivity.
And as we perhaps assess marriages and the sort of contracts that are being entered into, what sort of trend have you noticed over the years? Because, I mean, you know, it seemed as though marrying in community of property was the natural thing to do. But in terms of trends and lifestyle changes and how couples are entering into marriage, what have you noticed?
No one gets married in community of property, and I would never recommend that parties get married in community of property. What I see most is with young couples who start off with relatively little assets. They usually get married out of community of property with the accrual. However, I see people who enter into their second marriages, or businessmen or businesswomen, they elect for the option to be married out of community without the accrual.
And of course, clarifying with or without the accrual is something significant when you take a look at should you get a divorce and how much of your assets you'd be willing to split in half.
Yes, of course. And I think, simply put, what the accrual means is that what you make whilst you are married, from the date of marriage until the date of divorce, that you make together, that the parties will share. And it's unfortunate that mostly when clients come and sit across me from the table, initiating divorce proceedings, they don't know what their antenuptial contract means, what they signed, why they signed. And that's why I always advise people, seek the assistance of an attorney, find out what your contract says, because knowledge is power.
Very well. Thank you so much for that sound advice. Shani Van Niekerk, Senior Associate at Adams & Adams, speaking here of a case that has the potential to pave the way for divorcing spouses who are married out of community of property without the accrual system. So I suppose this will be an interesting one to watch, because it could mean a massive shift when it comes to marriage and contracts.